I am mentioning about the another persuasive authority, that is Board of Conciliation. The role is similar, there is not much difference, but here it would be going on at a higher degree with a higher professional approach. So, if the appropriate government thinks that the conciliation proceedings should be continued, but at a higher level, then the matter would be referred to Board of Conciliation, who is the second conciliatory authority under Industrial Disputes Act. Now, here there is a slight difference in the procedure. Instead of one single conciliation officer, there is going to be the conciliation officers referred by both the parties, one each. Then there would be one independent impartial person who act as a chairman of the board, and this would form a conciliation tribunal or what is called as Board of Conciliation, and this board is going to conduct a conciliation proceedings and try to come up with the amicable and acceptable settlement of the dispute. So, this is how the process is carried out under Industrial Disputes Act, where we have two officers, conciliation officer and Board of Conciliation, and the proceedings are almost similar. Now, let me move on to the next, Arbitration and Conciliation Act 1996. So, Arbitration and Conciliation Act is a product of UNCITRAL model law. Arbitration Conciliation Act is similar to other legislations in other legal systems. You take any other legal system in the world, and when it was passed to bring uniformity among the world, India had to repeal all the existing arbitration and conciliation laws. So, Arbitration Conciliation Act comes in three parts. Part 1 talks about arbitrations in India, where it repealed Arbitration Act 1940. Part 2 repealed two legislations which were a result of two conventions of the United Nations and one convention of League of Nations, that is Arbitration Protocol and Convention Act 1937, and second one is Foreign Awards Recognition and Enforcement Act 1960. Both these legislations were repealed by Arbitration and Conciliation Act 1996. Then there is part 3. This part 3, where I am going to discuss about, is about conciliation. So, the legislation has kept a separate part to deal with conciliation. So, under the 1996 legislation, conciliation scope is unlimited, anything, everything could be referred for conciliation. If you go by the language used in the section, it says all disputes relating to any legal relationship, whether contractual or not, should be referred to, could be referred to conciliation. So, we are talking about all disputes, we are talking about arising in a legal relationship, and we are ignoring important thing, that is whether it is a contractual or not. So, when you talk about legal relationship, the most of the relationship that exist in the society are all legal relationship, but they do not arise out of contract. Like your relationship with your neighbor, there is no contract between you, but you have certain you have duty to protect their rights and liabilities. But this blanket permission has got certain restrictions, where it says that certain kinds of disputes which cannot be conciliated because of the legislation, prohibition by the law. So, those things are not allowed. So, therefore, blanket permission comes up with a small restriction on it. So, once a dispute comes between the parties, they are going to, if they want to start a conciliation, how they are going to commence the conciliation. The commencement of conciliation is done through written communication. The party writes to other party, a party writes to conciliator, and parties agree for conciliation, and the conciliator agree to act as conciliator between the parties. So, that begins the conciliation. And this is the major I should say deviation from arbitration, where it requires existence of written arbitration agreement, but here such things are not required. So, what is required here is written invitation and acceptance of the invitation. So, when you write invitation requesting the parties to come for conciliation, the invitation must contain brief discussion on subject matter, major issues involved. So, therefore, they can come prepared what kind of steps they could take up. So, this is how the commencement of conciliation can take place, and during commencement process only there is appointment of appointment of conciliator. How many can act as a conciliator? Normally one person should be okay to run the conciliation show, because he being trusted by both the parties, he being having a faith of both the parties, he himself being independent and impartial, can control the conciliation proceedings very well. But the law provides that ordinarily one conciliator, but there can be 2 or more conciliators, and here there is no restriction that there should be only odd number of conciliators or uneven number of conciliators. So, there can be even number of conciliators who can function in a conciliation process. The simple reason is that the conciliation officer is not going to decide anything. So, when he is not an adjudicator authority, there is no risk of split decision. Odd number is maintained, uneven number is maintained, because in case of split decision, that decision becomes unenforceable. To avoid that, to ensure majority, we always have uneven number of adjudicatory authorities forming a tribunal, but here such risks do not exist. So, they do not insist on uneven number of conciliators. Now, this is, I find, kind of inspiration that is taken from Industrial Disputes Act, because when we go for board of conciliation, we go for a higher level of conciliation, there we have multiple conciliators sitting as conciliation board. So, now how do the procedure happens? First, conciliation officer being a stranger to the whole dispute, he would be having absolutely no idea about the dispute. So, therefore, first initial procedure is to appraise the conciliation officer with all the information relating to the dispute. For that purpose, the document should be sent by the parties to the conciliation officer. Now, here one precaution which must be followed by the parties is, all the communication that is made to the conciliator, same copy should be sent to other party also. Similarly, the other party which sends the communication to the conciliation officer, same thing is sent to this party. So, there is a complete communication between all the parties as well as the conciliation officer. After going through the documents, if the conciliation officer feels that he needs more information, then he can call for additional information as well. So, the role of the conciliator is assisting parties, developing positive dialogues between the parties, clarity as to the nature of dispute, clarity as to the interest of the parties, and clarifying the misunderstanding between the parties. So, this is going to be the major role of conciliation officer. And guiding principles, how conciliation officer should function. The most important thing is, he is not governed by CPC or Indian Evidence Act. So, therefore, there are no technicalities involved, there are no formalities involved, but there are certain principles he must not ignore. So, when he is dealing with parties, he must give due consideration to their past records, past dealings, previous practices, those things should be taken into consideration, plus circumstances around the dispute as well as the usage in the trade. If it is a business dispute, how the trade community deal with the dispute, what is the usage, what is the custom in the community, these things should be taken into consideration. In addition to that, other three things that should be considered is principles of objectivity, fairness of justice, and rights and obligations of the parties. This is how the conciliation would be worked out, and all the decisions relating to conciliation is always taken by the parties, and if parties fail to come to consensus, then it is the conciliation officer who takes all the decisions by consulting parties. So, he do not act as an authority over them, but he acts as an assistive partner to them. So, one important aspect of conciliation is private and joint sittings. When conciliation officer feels that he needs a private sitting with only one party, private sitting is meeting only one party in absence of the other party. With this, what happens? He build a good rapport with the other party and he can resolve the dispute without much delay. Similarly, he can sit with other private sitting with other party. Therefore, when we talk about joint and private sitting, it is a prerogative of the conciliation officer. Even parties can request that they want to have this private sittings, and these sittings are done to speed up the conciliation process. So, once the whole process is followed, then we come to the final leg, that is settlement agreement, most important part of the whole conciliation process. So, it is important not only because we are coming to an end to the dispute, it is also important because you should ensure that it will not lead to further dispute. So, drafting of settlement agreement happens to be the most important aspect of the whole conciliation process. So, first it has to be drafted, then it should be authenticated by the signature of the parties, conciliation officer. It is a duty of the conciliation officer that he should give full understanding of the terms of the agreement by explaining to the parties. There can be even partial settlement of the dispute, because certain areas they want it to be decided by the authorities, adjudicator authorities. It is the will of the parties. So, they can only come up with a partial settlement, remaining could be referred to adjudicator authorities, including arbitrators. So, once a settlement is drawn, settlement agreement is drafted, then it would be an arbitral award of on agreed terms. So, it has got a status of an award and it has got quite an enforceability in the eyes of the court. So, once the conciliation is successful, automatically the proceedings terminates, but sometimes when the conciliation is unsuccessful, there are different procedures in which you can terminate the proceedings, like party can give a written communication, say that they do not want to participate in conciliations anymore, that is the end of conciliation. Instead of parties, conciliation officer himself can mention that he is not willing to continue as there is no chance of settlement. So, that also brings an end to the conciliation proceedings. So, this is the brief discussion on conciliation. Let me browse through arbitration as quickly as possible. Again, it is a wrong notion, it is a myth that arbitration is a new concept. It was a part of Indian legal system from long time. Railways had arbitration clause in its law from 1777 itself. So, it is a very long time that it has been part of Indian legal system. So, therefore, you do not find definition of arbitration in any legislations. So, I have made a simple attempt to define what is arbitration. So, just try to distinguish between mediation, conciliation and arbitration when you listen to the definition. It is resolution of a dispute by a private judge. So, he is not a person, but a judge, and he is not a judge of a judiciary, but a private judge. He decides the dispute by passing a judgment called award. So, he is not encouraging parties to settle it, but he is deciding what party is supposed to do. And third important aspect is the decision of this private judge is binding on both the parties. So, this is how the arbitration functions.